Criminal Procedure, The Bar Lectures Series, by Willard Riano. Chapter 1 Preliminary Considerations. Basic Concepts. Criminal procedure treats of the series of processes by which the criminal laws are enforced and by which the state prosecutes persons who violate the penal laws. According to Black's Law Dictionary, criminal procedure is a generic term to describe the network of laws and rules which governs the procedural administration of justice. In People v. Laxon, the court stated that criminal procedure regulates the steps by which one who committed a crime is to be punished. The procedure starts with the initial contact of the alleged lawbreaker with the justice machinery, including the investigation of the crime, and concludes either with a judgment exonerating the accused or the final imposition of a penalty against him. The enforcement of the criminal laws of the state inevitably leads to governmental intrusions into an individual's zones of privacy, and how these intrusions can be reconciled with constitutional and statutory tenets protecting individual rights is an inescapable theme tackled in criminal procedure. Thus, in the prosecution for the violation of the penal laws, criminal procedures has the imposing task of balancing clashing societal interests primarily between those of the government and those of the individual. Hence, a common thread among innumerable treatises on the subject is the tendency to describe criminal procedure in relation to its ultimate goal of harmonizing the governmental functions of maintaining and promoting law and order law while at the same time protecting the constitutional rights of its citizens. The system of procedure in our jurisdiction is accusatorial or adversarial. Adversarial because it contemplates two contending parties, the prosecution and the defense, where each side tries to convince the court that its position is the correct version of the truth, and the court hears them impartially and renders judgment only after trial. In this system, the accusation starts with a formal indictment called in our jurisdiction as a complaint or an information, the allegations of which must be proven by the government beyond reasonable doubt. The government and the accused present their evidence before the court, which shall decide either on acquittal or conviction of the accused. In its decision-making process, that court shall consider no evidence which has not been formally offered. The court in this system, therefore, has a passive role and relies largely on the evidence presented by both sides to the action in order to reach a verdict. The adversarial system should be distinguished from the inquisitorial system, where the court plays a very active role and is not limited to the evidence presented before it. The court may utilize evidence gathered outside the court, and a judge or a group of judges under this system actively participates in the gathering of facts and evidence, instead of mere passively receiving information or evidence from the parties. The judge steers the course of the proceedings by directing and supervising the gathering of the evidence and the questioning of the witnesses to the case. The counsels in the inquisitorial system have a less active role than in the adversarial system. Liberal interpretation of the rules on criminal procedure, as part of the rules of court, shall be liberally construed in order to promote their objective of securing a just, speedy and inexpensive disposition of every action and proceeding as stated in Section 6, Rule 1, Rules of Court. In Sunita Caraga v. People of the Philippines, petitioner's former counsel erroneously appealed her conviction to the Court of Appeals instead of the Sandiganbayan. Petitioner pleaded that Section 2 of Rule 50 of the Rules of Court, which mandated the dismissal of cases erroneously appealed to the Court of Appeals, be relaxed and the Court of Appeals be directed to forward the records of the case to the Sandiganbayan. The Supreme Court, in granting petitioner's prayer, held that since the appeal involved a criminal case and the possibility of a person being deprived of liberty due to a procedural lapse is great, a relaxation of the rules was warranted. The rules of procedure must be viewed as tools to facilitate the attainment of justice, such that any rigid and strict application thereof which results in technicalities tending to frustrate substantial justice must always be avoided. Due process in criminal proceedings is mandatory and indispensable and cannot be met without the proverbial law, which hears before it condemns and proceeds upon inquiry and renders judgment only after trial. Money v. Savlano Jr. enumerates the requirements of due process in a criminal proceeding, to wit, a. that the court or tribunal trying the case is properly clothed with judicial power to hear and determine the matter before it. B. That jurisdiction is lawfully acquired by it over the person of the accused. C. That the accused is given opportunity to be heard, and D. That judgment is rendered only upon lawful hearing. Requisites for the exercise of criminal jurisdiction. A. Jurisdiction over the subject matter. B. Jurisdiction over the territory, and C. Jurisdiction over the person of the accused. Jurisdiction over the subject matter versus jurisdiction over the person of the accused. Jurisdiction over the subject matter refers to the authority of the court to hear and determine a particular criminal case, where the offense is one which the court is by law authorized to take cognizance of. Jurisdiction over the person of the accused refers to the authority of the court over the person charged, where the person charged with the offense must have been brought into its forum for trial, forcibly by warrant of arrest or upon his voluntary submission to the court. A. Jurisdiction over the territory, venue in criminal cases, Bar 1997. The concept of venue in actions in criminal cases, unlike in civil cases, is jurisdictional. Venue in criminal cases is an essential element of jurisdiction. Hence, for jurisdiction to be acquired by a court in a criminal case, the offense should have been committed or any one of its essential ingredients should have taken place within the territorial jurisdiction of the court. It is in that court where the criminal action shall be instituted. Section 15. A. Rule 110, Rules of Court. It is a doctrinal that in criminal cases, venue is an essential element of jurisdiction, and that the jurisdiction of a court over a criminal case is determined by the allegations in the complaint or information. The rule that the criminal action be instituted and tried in the court of the territory where the offense was committed or where any of its essential ingredients occurred is a fundamental principle, the purpose of which is not to compel the defendant to move to, and appear in, a different court from that of the province where the crime was committed, as it would cause him great inconvenience in looking for his witnesses and other evidence in another place. Territorial jurisdiction in criminal cases is the territory where the court has jurisdiction to take cognizance or to try the offense allegedly committed therein by the accused. Thus, it cannot take jurisdiction over a person charged with an offense allegedly committed outside of that limited territory, and if the evidence adduced during the trial shows that the offense was committed somewhere else, the court should dismiss the action for a want of jurisdiction as stated in Mukasat v. People. Exception to this rule, when a court has jurisdiction to try offenses not committed within its territorial jurisdiction. Section 15d, Rule 110, Rules of Court. 1. Where the offense was committed under the circumstances enumerated in Article 2 of the Revised Penal Code. A. Should commit an offense while on a Philippine ship or airship. B. Should forge or counterfeit any coin or currency note of the Philippines or obligations and securities issued by the Philippines. C. Should introduce these obligations and securities in the Philippines. D. While being public officers and employees, should commit an offense in the exercise of their functions. E. Should commit any of the crimes against national security and the law of nations. Included in crimes against national security are the crimes of 1. Treason, 2. Conspiracy and proposal to commit treason, 3. Misprision of treason, 4. Espionage, 5. Inciting to war and giving motives for reprisal, 6. Violation of neutrality, 7. Correspondence with hostile country, and 8. Flight to enemy's country. Articles 114-121, Revised Penal Code. Crimes against the law of nations are piracy, qualified piracy and mutiny described under Article 122 and 123 of the Revised Penal Code. These crimes shall be enforced not only within the Philippines but also outside of its jurisdiction. In this case, the offense shall be cognizable by the court where the criminal action is first filed. Exception 2. Where the Supreme Court, pursuant to its constitutional powers, orders a change of venue or a place of trial to avoid a miscarriage of justice. Section 5, Article 3 of the 1987 Constitution. 3. Where an offense is committed in a train, aircraft, or other public or private vehicle in the course of its trip, the criminal action need not be instituted in the actual place where the offense was committed. It may be instituted and tried in the court of any municipality or territory where said train, aircraft, or vehicle passed during its trip or in the place of departure and arrival. Section 15b, Rule 110 of Rules of Court. 4. Where an offense is committed on board a vessel in the course of its voyage, the criminal action shall be instituted and tried not necessarily in the place of the commission of the crime. It may be brought and tried in the court of the first port of entry, or in the municipality or territory where the vessel passed during the voyage. Section 15c, Rule 110 of Rules of Court. 5. Where the case is cognizable by the Sandiganbayan, the jurisdiction of which depends upon the nature of the offense and the position of the accused, the offense need not be tried in the place where the act was committed but where the court actually sits in Quezon City. Under Section 2 of RA, number 8249, an act further defining the jurisdiction of the Sandiganbayan, when the greater convenience of the accused and of the witnesses, or other compelling considerations so require, a case originating from one geographical region may be heard in another geographical region. For this purpose, the presiding justice shall authorize any divisions of the court to hold sessions at any time and place outside Metro Manila and, where the interest of justice so requires, outside the territorial boundaries of the Philippines. Exception 6. Where the offense is written defamation, the criminal action need not necessarily be filed in the RTC of the province or city where the alleged libelous article was printed and first published. It may be filed in the province or city where the offended party held office at the time of the commission of the offense if he is a public officer, or in the province or city where he actually resided at the time of the commission of the offense in case the offended party is a private individual. Bar 1995 Question. The case of Agbayani v. Sao, restated Article 360 of the Revised Penal Code, written defamation, as follows. A. Whether the offended party is a public official or a private person, the criminal action may be filed in the court of first instance, RTC, of the province or city where the libelous article is printed and first published. B. If the offended party is a private individual, the criminal action may also be filed in the court of first instance, RTC, of the province where he actually resided at the time of the commission of the offense. C. If the offended party is a public officer whose office is in Manila at the time of the commission of the offense, the action may be filed in the RTC of Manila. D. If the offended party is a public officer holding office outside of Manila, the action may be filed in the RTC of the province or city where he held office at the time of the commission of the offense. One recent case held that if the circumstance as to where the libel was printed and first published is used by the offended party as basis for the venue in the criminal action, the information must allege with particularity where the defamatory article was printed and first published, as evidenced or supported by, for instance, the address of their editorial or business offices in the case of newspapers, magazines or serial publications. This precondition becomes necessary in order to forestall any inclination to harass. In a case pertaining to defamatory material appearing on a website on the Internet, the place where the material was first accessed cannot be equated with printing and first publication. This interpretation would, said the court, spawn the very ills that the amendment to Article 360 of the RPC sought to discourage and prevent. It hardly requires much imagination to see the chaos that would ensue in situations where the website's author or writer, a blogger or anyone who posts messages therein could be sued for libel anywhere in the Philippines that the private complainant may have allegedly accessed the offending website. In Foz Jr. vs. People, merely alleging that the offended party is a physician and medical practitioner in a particular place, does not clearly and positively indicate that said person is residing in such place at the time of the commission of the crime. One who transacts business in a place and spends a considerable time in there does not render such person a resident in it. B. Criminal jurisdiction over the subject matter. Jurisdiction over the subject matter is the power to hear and determine cases of the general class to which the proceedings in question belongs. It is the power to deal with the general subject involved in the action, and means not simply jurisdiction over the particular case then occupying the attention of the court but jurisdiction of the class of cases to which the particular case belongs. How is it conferred? Jurisdiction over the subject matter is conferred by law. It is the law that confers jurisdiction and not the rules. When the law confers jurisdiction, that conferment must be clear. It cannot be presumed. It must clearly appear from the statute or it will not be held to exist. Because of this, jurisdiction cannot be fixed by the will of the parties nor can it be acquired or diminished by any act of the parties. Also it cannot be conferred upon the court by the accused's express waiver or otherwise, nor be conferred by mere administrative policy of any trial court. How jurisdiction over the subject matter is determined. While jurisdiction of courts is conferred by law, jurisdiction over a criminal case is determined by the allegations in the complaint or information. Hence, in order to determine the jurisdiction of the court in criminal cases, the complaint or information must be examined for the purpose of ascertaining whether or not the facts set out therein and the punishment provided for by law for such acts fall within the jurisdiction of the court in which the criminal action is filed. If the facts set out in the complaint or information are sufficient to show that the court has jurisdiction, then that court indeed has jurisdiction. The jurisdiction of the court is defined by the Constitution or statute. The elements of that definition must appear in the complaint or information so as to ascertain which court has jurisdiction over a case. It was held, however, that if the evidence adduced during the trial shows that the offense was committed somewhere else, the court should dismiss the action for a want of jurisdiction as stated in McCassett v. People. Thus, in criminal cases, the court must examine the complaint for the purpose of ascertaining whether or not the facts set out and the punishment provided by law for such act fall within the jurisdiction of the court. In cases cognizable by the Sandiganbayan, both the nature of the offense and the position occupied by the accused are conditions sine qua non before the Sandiganbayan can validly take cognizance of the case. In complex crimes, jurisdiction is with the court having jurisdiction to impose the maximum and most serious penalty imposable on the offense forming part of the complex crime. Usually the RTC statute applicable to a criminal action. 1. It is a Hornbook doctrine that jurisdiction to try a criminal action is determined by the law in force at the time of the institution of the action and not during the arraignment of the accused. 2. The statute in force at the time of the institution of the action determines the jurisdiction of the court over the subject matter, and not at the time of its commission even if the penalty that may be imposed at the time of its commission is less and does not fall under the court's jurisdiction. 3. In the case of People v. Sandiganbayan and Victoria Almonte, where the offense was allegedly committed on 1995 and the filing of the information was on 2004, the jurisdiction of the Sandiganbayan to try a criminal case is mandated by the PD 1606 of 1997 and not the earlier law of 1995, because the law applicable is to be determined at the time of the institution of the action, not at the time of the commission of the offense. Use of the imposable penalty. 1. In determining whether or not the court has jurisdiction over an offense, we consider the penalty which may be imposed upon the accused and not the actual penalty imposed after the trial. 2. The jurisdiction of the court is not determined by what may be meted out to the offender after trial, or even by the result of the evidence that would be presented at the trial, but by the extent of the penalty which the law imposes for the offense, on the basis of the facts alleged in the information or complaint. Principle of adherence of jurisdiction or continuing jurisdiction. 1. The jurisdiction of the court is referred to as continuing in view of the general principle that once a court has acquired jurisdiction, that jurisdiction continues until the court has done all that it can do in the exercise of that jurisdiction. For instance, in Flores v. Sumaljag, the court was held not to have lost jurisdiction over the case involving a public official by the mere fact that the said official ceased to be in office during the pendency of the case. the court retains its jurisdiction either to pronounce the respondent official innocent of the charges or declare him guilty thereof. A recognized exception to this rule is when the statute expressly so provides, or is construed to the effect that it is intended to operate upon actions pending before its enactment. However, when no such retroactive effect is provided for, statutes altering the jurisdiction of a court cannot be applied to cases already pending prior to their enactment. As a result of the above rule, once a complaint or information is filed in court, any disposition of the case such as its dismissal or continuance rests on the sound discretion of the court, and even if the prosecution files a motion to withdraw the information, the court may grant or deny the same in the faithful exercise of judicial prerogative. Dismissal on jurisdictional grounds. Special Appearance 1. The rule is settled that an objection based on the ground that the court lacks jurisdiction over the subject matter may be raised or considered motu proprio by the court at any stage of the proceedings or on appeal. 2. A special appearance before the court to challenge the jurisdiction of the court over the person is not tantamount to estoppel or waiver of the objection, and is not a voluntary submission to the jurisdiction of the court. Raising the issue of jurisdiction for the first time in the Supreme Court. 1. An accused is not precluded from raising the issue of jurisdiction of the trial court over the offense charged, because the issue may be raised or considered motu proprio by the court at any stage of the proceedings or on appeal. Moreover, jurisdiction over the subject matter in a criminal case cannot be conferred upon the court by the accused, by express waiver or otherwise, since such jurisdiction is conferred by the sovereign authority which organized the court and is given only by law in the manner and form prescribed by law. However, a party cannot invoke the jurisdiction of the court to secure affirmative relief against his opponent, and after obtaining or failing to obtain such relief, repudiate or question that same jurisdiction. After voluntarily submitting a cause and encountering an adverse decision on the merits, it is too late for the loser to question the jurisdiction or power of the court. While the jurisdiction of a tribunal may be challenged at any time, sound public policy bars one from doing so after their having procured that jurisdiction, speculating on the fortunes of litigation. The rule is the same as in civil cases. In Tijam vs. Sibong Anoi, the court earlier ruled that a party may be stopped from questioning the jurisdiction of the court for reasons of public policy as when he initially invokes the jurisdiction of the court, and then later on repudiates that same jurisdiction. However, the doctrine of estoppel laid down in Tijam is an exception and not the general rule, and the rule still stands that jurisdiction is vested by law and cannot be conferred or waived by the parties. Hence, even on appeal, and even if the reviewing parties did not trace the issue of jurisdiction, the reviewing court is not precluded from ruling that the lower court had no jurisdiction over the case. C. Criminal jurisdiction over the person of the accused. Bar 2008. 1. It was held that jurisdiction over the person of the accused is acquired upon his arrest or apprehension, with or without a warrant, or his voluntary appearance or submission to the jurisdiction of the court. As a general rule, seeking affirmative relief is deemed to be a submission to the jurisdiction of the court. Sapuga vs. Court of Appeals. 2. The assertion that the court never acquired jurisdiction over the person of the accused, because the warrant of arrest issued is null and void because no probable cause was found by the court issuing it, cannot be sustained because he posted a bail. The giving or posting of a bail by the accused is tantamount to submission of his person to the jurisdiction of the court. Even if it is conceded that the warrant issued was void, the defendant waived all his rights to object by appearing and giving a bond. Gowanko Jr. vs. Sandiganbayan. By submitting oneself to the jurisdiction of the court as shown by entering into a counsel-assisted plea, the active participation in the trial and presenting evidence for the defense, the accused is deemed to have waived his constitutional protection against illegal arrest. People vs. Rivera. 3. However, not all acts seeking affirmative relief would constitute a voluntary appearance or submission to the jurisdiction of the court. Making a special appearance in court to question the jurisdiction of the court over the person of the accused, is not a voluntary appearance as when in a criminal case a motion to quash is filed precisely on that ground. There is likewise no submission to the jurisdiction of the court when the accused files a motion to quash the warrant of arrest, because it is the very legality of the court process forcing the submission of the person of the accused that is the very issue in a motion to quash a warrant of arrest. 4. Being in the custody of the law is not necessarily being under the jurisdiction of the court. One can be under the custody of the law but not yet subject to the jurisdiction of the court over his person, such as when a person arrested by virtue of a warrant files a motion before arraignment to quash the warrant. On the other hand, one can be subject to the jurisdiction of the court over his person, and yet not be in the custody of the law, as when an accused escapes custody after his trial has commenced. Being in the custody of the law signifies restraint on the person, who is thereby deprived of his own will and liberty, binding him to become obedient to the will of the law. Custody of the law is literally custody over the body of the accused. It includes, but is not limited to, detention. D. Injunction to restrain criminal prosecution, bar 1999. As a general rule, the court will not issue writs of prohibition or injunction preliminary or final, to enjoin or restrain criminal prosecution. With more reason will injunction not lie when the case is still at the stage of preliminary investigation or reinvestigation. However, in extreme cases, the court laid the following exceptions. 1. When the injunction is necessary to afford adequate protection to the constitutional rights of the accused. 2. When it is necessary for the orderly administration of justice or to avoid oppression or multiplicity of actions. 3. When there is a prejudicial question which is sub judice. 4. When the acts of the officer are without or in excess of authority. 5. Where the prosecution is under an invalid law, ordinance or regulation. 6. When double jeopardy is clearly apparent. 7. Where the court has no jurisdiction over the offense. 8. Where it is a case of persecution rather than prosecution. 9. Where the charges are manifestly false and motivated by the lust for vengeance. And, 10. When there is clearly no prima facie case against the accused and a motion to quash on that ground has been denied. E. Mandamus to compel prosecution, bar 1999. 1. Mandamus is a remedial measure for parties aggrieved which shall be issued when any tribunal, corporation, board, officer or person unlawfully neglects the performance of an act which the law specifically enjoins as a duty resulting from an office, trust or station. The writ of mandamus is not available to control discretion, neither may it be issued to compel the exercise of discretion. Truly, it is a matter of discretion on the part of the prosecutor to determine which persons appear responsible for the commission of a crime. However, the moment he finds one to be so liable, it becomes his inescapable duty to charge him therewith and to prosecute him for the same. In such a situation, the rule loses its discretionary character and becomes mandatory. If despite the sufficiency of the evidence before the prosecutor, he refuses to file the corresponding information against the person responsible, he abuses his discretion. His act is tantamount to a deliberate refusal to perform a duty enjoined by law. The Secretary of Justice, on the other hand, would gravely abuse his discretion when, despite the existence of sufficient evidence for the crime as acknowledged by the investigating prosecutor, he completely ignored the latter's finding and proceeded with the question resolution anchored on purely evidentiary matters in utter disregard of the concept of probable cause. To be sure, findings of the Secretary of Justice are not subject to review unless shown to have been made with grave abuse, but a case like this calls for the application of an exception. 2. Generally, a public prosecutor is afforded a wide latitude of discretion in the conduct of a preliminary investigation. By way of exception, however, judicial review is allowed where a respondent has clearly established that the prosecutor committed grave abuse of discretion, that is, when he has exercised his discretion in an arbitrary, capricious, whimsical or despotic manner by reason of passion or personal hostility, patent and gross enough as to amount to an evasion of a positive duty or virtual refusal to perform a duty enjoined by law. Criminal jurisdiction of courts. A. Criminal jurisdiction of the Municipal Trial Court, Municipal Circuit Trial Court, and Metropolitan Trial Court, MTC. Except in cases falling within the exclusive original jurisdiction of the Regional Trial Court and of the Sandiganbayan, the MTC shall exercise the following criminal jurisdiction. 1. Exclusive original jurisdiction over all violations of city or municipal ordinances committed within their respective territorial jurisdiction. 2. Exclusive original jurisdiction over all offenses punishable with imprisonment not exceeding 6 years irrespective of the amount of fine, and regardless of other imposable or accessory penalties, including the civil liability arising from such offenses irrespective of kind, nature, value or amount. This rule disregarding the amount of the fine and other accessory penalties in determining jurisdiction, applies where the offense is punishable by imprisonment or fine or both, but not when the offense is punishable by fine only. Note that the jurisdiction of the MTC is qualified by the phrase, except in cases falling within the exclusive jurisdiction of the Regional Trial Court and of the Sandiganbayan. This indicates that the MTC does not at all times have jurisdiction over offenses punishable with imprisonment not exceeding 6 years. If jurisdiction is vested by law either in the RTC or Sandiganbayan, based on Article 27 of the RPC, the MTC has jurisdiction over offenses punishable by up to the maximum of Provisional, which shall not exceed 6 years. There are however, offenses which even if punishable by Provisional, are not cognizable by the MTC because of an express provision of law, like libel as defined in Article 355 of the RPC. Under this provision, libel by means of writings or similar means shall be punishable by Provisional, in its minimum and medium periods, or a fine ranging from 200 pesos to 6,000 pesos or both. Nevertheless, under Article 360 of the RPC, the criminal action as well as the civil action for such offense, shall be filed simultaneously or separately with the RTC. Also, some forms of direct bribery under Article 210 of the RPC which are punishable by Provisional in its medium period, are within the exclusive jurisdiction of the Sandiganbayan pursuant to Section 4A of PD 1606 as amended. Indirect bribery, a felony punishable by Provisional in its medium and maximum periods under Article 211 of the RPC are likewise cognizable by the Sandiganbayan, pursuant to Section 4A of PD 1606 as amended. 3. Where the only penalty provided for by law is a fine, the amount thereof shall determine the jurisdiction of the court under the original provisions of BP 129, which provided that the MTC shall have exclusive original jurisdiction over offenses punishable with a fine of not more than 4,000 pesos. 4. Exclusive original jurisdiction over offenses involving damage to property through criminal negligence. 5. Violations of BP 22, bouncing checks law. 6. Summary procedure in the following cases. A. Violations of traffic laws, rules and regulations, violations of the rental law, and violations of municipal or city ordinances. B. All other criminal cases where the penalty prescribed by law for the offense charged is imprisonment not exceeding 6 months, or a fine not exceeding 1,000 pesos or both, irrespective of other imposable penalties, accessory or otherwise, or of the civil liability arising therefrom. C. Offenses involving damage to property through criminal negligence where the imposable fine does not exceed 10,000 pesos. 7. Special jurisdiction to decide on applications for bail in criminal cases in the absence of all RTC judges in a province or city. B. What are the criminal jurisdiction of Regional Trial Court? 1. Exclusive original jurisdiction in all criminal cases, not within the exclusive jurisdiction of any court, tribunal or body, except those now falling under the exclusive and concurrent jurisdiction of the Sandiganbayan. 2. Appellate jurisdiction over all cases decided by the MTC within its territorial jurisdiction. 3. Special jurisdiction to handle exclusively criminal cases as designated by the Supreme Court. 4. Jurisdiction over criminal cases under specific laws such as a. Written defamation, Article 360, RPC, b. Jurisdiction of designated courts over cases in violation of the Comprehensive Dangerous Drugs Act of 2002, c. Violations of intellectual property rights. The public prosecutor has the authority to file a criminal information for violation of PD 957 and the regional trial court has the power to hear and adjudicate the action, the penalty being a 20,000 pesos fine and imprisonment of not exceeding 10 years, or both such fine and imprisonment. This penalty brings the offense within the jurisdiction of the regional trial court. 5. Jurisdiction in money laundering cases. The regional trial courts shall have jurisdiction to try all cases on money laundering. Those committed by public officers and private persons, who are in conspiracy with such public officers shall be under the jurisdiction of the Sandiganbayan. C. Criminal jurisdiction of the Sandiganbayan. 1. The jurisdiction of the Sandiganbayan is set by PD 1606 as amended and not by RA 3019 or the Anti-Graft and Corrupt Practices Act as amended. 2. The applicable law provides, Section 4, Jurisdiction. The Sandiganbayan shall exercise original jurisdiction in all cases involving a. Violations of Republic Act No. 3019, otherwise known as the Anti-Graft and Corruption Practices Act, and Republic Act No. 1379, and Chapter 2, Section 2, Title 7, Book 2 of the RPC, where one or more of the accused are officials occupying the following positions in the government, whether in a permanent, acting or interim capacity, at the time of the commission of the offense. 1. Officials of the executive branch occupying the positions of regional director and higher, otherwise classified as grade 27 and higher of the Compensation and Position Classification Act of 1989, Republic Act No. 6758, specifically including a. Provincial governors, vice-governors, members of the Sangguniang Panlalawigan, and provincial treasurers, assessors, engineers, and other provincial department heads. B. City mayors, vice-mayors, members of the Sangguniang Panlungsod, city treasurer, assessors, engineers, and other city department heads. C. Officials of the diplomatic service occupying the position of consul and higher. D. Philippine Army and Air Force colonels, naval captains, and all officers of higher rank. E. Officers of the Philippine National Police while occupying the position of provincial director, and those holding the rank of senior superintendent or higher. F. City and provincial prosecutors and their assistants, and officials and prosecutors in the office of the Ombudsman and Special Prosecutor. G. Presidents, directors or trustees, or managers of government-owned or controlled corporations, state universities or educational institutions or foundations. Number 2. Members of Congress and officials thereof classified as grade 27 and up. 3. Members of the judiciary without prejudice to the provisions of the Constitution. 4. Chairmen and members of constitutional commissions, without prejudice to the provisions of the Constitution. And 5. All other national and local officials classified as grade 27 and higher. B. Other offenses or felonies whether simple or complexed with other crimes, committed by the public officials and employees mentioned in subsection A of this section in relation to their office. C. Civil and criminal cases filed pursuant to and in connection with Executive Order Numbers 1, 2, 14 and 14A. Issued in 1986. In cases where none of the accused are occupying positions corresponding to salary grade 27 or higher, or military and plug-and-play officers mentioned above, exclusive original jurisdiction thereof shall be vested in the proper regional trial court, or MTC, as the case may be, pursuant to their respective jurisdictions as provided in BP 129. As amended, the Sandiganbayan shall exercise exclusive appellate jurisdiction over final judgments, resolutions or orders of regional trial courts, whether in the exercise of their own original jurisdiction or of their appellate jurisdiction as herein provided. The Sandiganbayan shall have exclusive original jurisdiction over petitions for the issuance of the writs of mandamus, prohibition, certiorari, habeas corpus, injunctions, and other ancillary writs and processes in aid of its appellate jurisdiction, and over petitions of similar nature, including quo warranto, arising or that may arise in cases filed or which may be filed under Executive Order Nos. 1, 2, 14 and 14a, issued in 1986, provided that the jurisdiction over these petitions shall not be exclusive of the Supreme Court. The procedure prescribed in BP 129, as well as the implementing rules that the Supreme Court has promulgated and may hereafter promulgate, relative to appeals or petitions for review to the Court of Appeals, shall apply to appeals and petitions for review filed with the Sandiganbayan. In all cases elevated to the Sandiganbayan and from the Sandiganbayan to the Supreme Court, the Office of the Ombudsman through its Special Prosecutor, shall represent the people of the Philippines except in cases filed pursuant to Executive Order Nos. 1, 2, 14 and 14a, issued in 1986. In case private individuals are charged as co-principals, accomplices or accessories with the public officers or employees, including those employed in government-owned or controlled corporations, they shall be tried jointly with said public officers and employees in the proper courts which shall exercise exclusive jurisdiction over them. Offenses subject to the jurisdiction of the Sandiganbayan, Bar 1997. Question 1. The phraseology of the governing law discloses that the jurisdiction of the Sandiganbayan is not confined to violations of the Anti-Graft and Corrupt Practices Act. Specifically, the following offenses are subject to the jurisdiction of the Sandiganbayan: a. Violations of Republic Act No. 3019 as amended, otherwise known as the Anti-Graft and Corrupt Practices Act. B. Violations of Republic Act No. 1379 or otherwise known as the Act declaring forfeiture in favor of the state any property found to have been unlawfully acquired by any public officer or employee. C. Violations of Chapter 2, Section 2, Title 7, Book 2 of the RPC. These offenses refer to the law on bribery in all its forms including corruption of public officers. Articles 210-212, RPC. D. Other offenses or felonies, aside from the above, whether simple or complexed with other crimes, committed by public officials violating the Anti-Graft and Corrupt Practices Act. Thus, in Serrano v. Sandiganbayan, the court declared in no uncertain terms, that the Sandiganbayan has jurisdiction over felonies committed by public officials in relation to their office. The court further held that estafa is one of those felonies, and the Sandiganbayan has jurisdiction if 1. The offense is committed by a public official or an employee mentioned in Section 4, Paragraph A, and 2. The offense is committed in relation to his office. In another case, the accused argues that the crime of falsification as defined under Articles 171 and 172 of the RPC, is not within the jurisdiction of the Sandiganbayan. The court struck down the argument and ruled that falsification of public document under the RPC is within the jurisdiction of the Sandiganbayan. E. Civil and criminal offenses filed pursuant to and in connection with Executive Order Nos. 1, 2, 14 and 14a issued in 1986, Section 4C, PD 1606 as amended. These executive orders refer to orders on sequestration cases. 1. Should one or more of the officials charged have a salary grade of 27 or higher for the Sandiganbayan to have jurisdiction over the case, it is submitted that the query be answered in the negative. The salary grade of 27 has no reference, for example, to provincial governors, vice governors or members of the Sangguniang Panlalagan, Sangguniang Panglunsod, directors or managers of government-owned or controlled corporations, city mayors, vice mayors, city treasurers, assessors, engineers, trustees of state universities, and other officials enumerated in Section 4 of Presidential Decree 1606 as amended. Those enumerated are subject to the jurisdiction of the Sandiganbayan regardless of salary grade. Thus, if the accused does not belong to the national and local officials enumerated, in order for the Sandiganbayan to acquire jurisdiction over the offense, the same must be committed by officials classified as grade 27 and higher, aside from other officials, expressly covered. 2. Instructive is the ruling of the court in Ending v. Sandiganbayan. Clearly, therefore, Congress intended these officials regardless of their salary grades, to be specifically included within the Sandiganbayan's original jurisdiction, for had it been otherwise, then there would have been no need for such enumeration. This conclusion is further bolstered by the fact that some of the officials enumerated in A-G are not classified as SG 27 or higher under the position titles and salary grades of the Department of Budget and Management. Officers falling below salary grade 27-1, G. Despan vs. People, raised the issue on whether or not the Sandiganbayan has jurisdiction over a regional director, manager of government-owned or controlled corporations, organized and incorporated under the Corporation Code for purposes of RA 3019, the Anti-Graft and Corrupt Practices Act. The petitioner assumed a negative view in a petition for certiorari under Rule 65 filed with the Supreme Court. The Office of the Special Prosecutor argued otherwise, a view shared by the Sandiganbayan. The records showed that, although the petitioner was a director of Region 6 of the PhilHealth, she was not occupying the position of regional director but that of department manager in accordance with her appointment papers. It is petitioner's appointment paper, and the notice of salary adjustment that determined the classification of her position, that is, department manager of PhilHealth. The petitioner admitted that she holds the position of department manager of PhilHealth. She, however, contended that the position of department manager is classified under salary grade 26 and therefore outside the jurisdiction of respondent court. The court found that the petitioner held the position of department director of PhilHealth at the time of the commission of the offense, and that position is among those enumerated in paragraph 1G, section 4A of RA 8249. Over which the Sandiganbayan has jurisdiction and which provision includes presidents, directors or trustees, or managers of government-owned and controlled corporations, state universities or educational institutions or foundations. It is of no moment, added the court, that the position of petitioner was merely classified as salary grade 26. While the first part of Section 4 of PD 1606 covers only officials of the executive branch with the salary grade 27 and higher, the second part thereof specifically includes other executive officials whose positions may not be of grade 27 and higher, but who are by express provision of law placed under the jurisdiction of the said court. Salary grade alone does not determine jurisdiction of the Sandiganbayan. It is not only the salary grade that determines the jurisdiction of the Sandiganbayan. The Sandiganbayan also has jurisdiction over other officers enumerated in PD 1606 as amended. While the first part of Section 4A of the law covers only officials with salary grade 27 and higher, its second part specifically includes other executive officials whose positions may not be with salary grade 27 or higher, but who are by express provision of the law placed under the jurisdiction of said court. A student regent of a state university is a public officer. The petitioner in one case contended that the Sandiganbayan has no jurisdiction over her person. As a student regent, she claimed she was not a public officer since she merely represented the students of the institution, in contrast to the other regents who held their positions in an ex officio capacity. She added that she was just a simple student and did not receive any salary as a student regent, and thus could not fall under any salary grade. The argument that she was not a public officer was struck down by the court. The petitioner is a public officer whose position is covered by the law vesting jurisdiction over the Sandiganbayan. The provisions PD 1606 as amended, explicitly vested the Sandiganbayan with jurisdiction over presidents, directors or trustees, or managers of government-owned or controlled corporations, state universities or educational institutions or foundations. The petitioner, as a student regent, falls under this category. The Board of Regents of the University of the Philippines performs functions similar to those of a Board of Trustees of a non-stock corporation. By express mandate of the law, the petitioner declared the court is a public officer as contemplated by PD 1606. The court added that compensation is not an essential element of a public office, and is merely incidental to the public office. Serrano v. Sandiganbayan. Offenses committed in relation to the office. 1. As a rule, to make an offense when committed in relation to the office, the relation has to be such that, in the legal sense, the offense cannot exist without the office. In other words, the office must be a constituent element of the crime as defined by statute, such as, for instance, the crimes defined and punished in Chapter 2 to 6. Title 7 of the RPC, like direct bribery, frauds against the public treasury, malversation of public funds and property, failure of an accountable officer to render accounts, illegal use of public funds or property, or any of the crimes from Articles 204 to 245 of the RPC. 2. Public office is not an element of the crime of murder, since murder may be committed by any person, whether a public officer or a private citizen. Public office is not the essence of murder. The taking of human life is either murder or homicide, whether done by a private citizen or public servant. There is also no direct relation between the commission of the crime of rape with homicide, and the office as municipal mayor, because public office is not an essential element of the crime charged. The offense can stand independently of the office. 3. However, even if the position is not an essential ingredient of the offense charged, if the information avers the intimate connection between the office and the offense, this would bring the offense within the definition of an offense committed in relation to the public office. Summary procedure in criminal cases. 1. The Metropolitan Trial Courts, the Municipal Trial Courts in cities, the Municipal Trial Courts and the Municipal Circuit Trial Courts shall have jurisdiction over cases falling under summary procedure committed within their jurisdiction. Section 1. The 1991 Rule on Summary Procedure. 2. The following cases are subject to summary procedure. A. Violations of traffic laws, rules and regulations. B. Violations of the rental law and BP 22, bouncing check law. C. Violations of municipal or city ordinances. D. All other criminal cases where the penalty prescribed by law for the offense charged is imprisonment not exceeding 6 months, or a fine not exceeding 1,000 pesos, or both, irrespective of other imposable penalties, accessory or otherwise, or of the civil liability arising therefrom. E. Offenses involving damage to property through criminal negligence where the imposable fine does not exceed 10,000 pesos. 3. The filing of criminal cases under summary procedure may be either by complaint or information. In Metro Manila and other chartered cities, the filing shall be by information except when the offense is one which cannot be prosecuted de officio. The complaint or information shall be accompanied by the affidavits of the complainant and his witnesses, in such number of copies as there are accused, plus 2 copies for the court's files. This requirement has to be complied with within 5 days from the filing of the case, otherwise the same may be dismissed. 5. Before conducting the trial, the court shall call the parties to a preliminary conference during which the following may be done. A. Entering into a stipulation of facts. B. Considering the propriety of allowing the accused to enter a plea of guilty to a lesser offense, or, C. Taking up such other matters to clarify the issues and to ensure a speedy disposition of the case. 6. If the accused refuses to stipulate or fails to do so, such refusal or failure shall not prejudice the accused. Also, any admission of the accused made during the preliminary conference must be reduced to writing and signed by the accused and his counsel. If this requirement is not met, such admission shall not be used against him. 7. During the trial, an actual direct examination of the witnesses is not required, because the affidavits submitted shall constitute their direct testimonies. The witnesses, however, may be subjected to a cross-examination, redirect examination or re-cross-examination. Should the affiant fail to testify, his affidavit shall not be considered as competent evidence for the party presenting the affidavit. However, the adverse party may utilize the same for any admissible purpose. 8. The court is mandated not to order the arrest of the accused, except where the ground is his failure to appear when required by the court. If he is arrested, he may be released on bail or on recognizance by a responsible citizen acceptable to the court. 9. Where a trial has been conducted, the court shall promulgate the judgment not later than 30 days after the termination of the trial. Prohibited pleadings, motions and petitions in summary procedure, Bar 2004, civil and criminal cases. 1. Motion to quash the complaint or information, except if the ground is lack of jurisdiction over the subject matter or failure to comply with the barangay conciliation proceedings. 2. Motion for bill of particulars. 3. Motion for new trial, or for consideration of a judgment, or for reopening of trial. 4. Petition for relief from judgment. 5. Motion for extension of time to file pleadings, affidavits or any other paper. 6. Memoranda. 7. Petition for certiorari, mandamus, or prohibition against any interlocutory order issued by the court. 8. Motion to declare the defendant in default. 9. Dilatory motions for postponement. 10. Reply. 11. Third-party complaints. 12. Interventions.